Hello, everyone. Thank you very much for waiting and a very warm welcome to our webinar on IR35, everything you need to know. So that's quite a lofty goal, but I think we'll cover as many topics as we can that are relevant today. So as I said, a warm welcome to all our guests that have joined us today. We appreciate your support on our webinars over the last 2 years, and I'm really pleased to extend a warm welcome to our speakers today, who are Gareth Walls and Julia Kermode. And I hope you don't mind me saying, guys, but friends of the show, friends of CXC, and friends of ours. And it's great to have you back on the webinar. I think the last one we did as a three-way was last August 2021. And of course, the world was very different then, wasn't it? We were probably wearing shirts and ties. We were probably locked down, I think, or at least restricted. We were probably wearing a mask everywhere. There was no war in Ukraine, thank goodness. Inflation was stable. And of course, the soft landing, the much vaunted soft landing, was still in place as it relates to IR35. So I think it's a very interesting time, guys. In relation to IR35, there's a lot of concern, discord around the soft landing ending, and we're going to cover that shortly. But one of the things that's really interested me, folks, in relation to IR35 is that there's still a large number of enterprises that are really grappling to fully implement measures to determine whether their workers are truly inside or outside IR35 and how to manage that whole process. And it's pleasantly surprised me, I suppose, on our own business side here at CXC, but it does strike me that there's a problem out there in terms of messaging, understanding, and let's be frank, Julia, Gareth, myself, and many others in our respective organizations have an innate understanding and expertise in this space. But I suppose if you're the procurement or HR director in an enterprise and you're not a trained lawyer, or you don't have a real interest in contractor classification or misclassification law, it's probably quite a difficult concept to grasp in its entirety and how to roll that out. So we feel for folks that are still struggling with this as well. But I think the other thing that we have noticed, and certainly we're getting a lot of inquiries around, is the CEST tool. So HMRC's own tool for helping organizations classify or determine a worker's IR35 status. And of course, that tool has been much criticized by not just us, but also organizations such as KPMG and the BBC. And just looking at the CEST tool, during the period 25th of November 2019 to 31st of May 2021, 1 million users ran CEST checks, and approximately 21% of those users were issued indeterminate status, right? So that's problematic. So if it's indeterminate, what the hell do you do? Do you run them again? Do you game the system? Of course, you don't want to game the system, but it's problematic, and it creates uncertainty, it creates complexity, and potentially it creates ambiguity when it comes to IR35. So what we really want to do today, folks, is shine a light on this. And I think before we move into some of the items that you've probably seen that we want to discuss, the soft landing, the risks of misclassification or reclassification, how the future looks for workers in the UK that are inside or outside IR35, the problems that this might provide in the labour market, we really just want to look at what is IR35 as it pertains to the private sector. What should organizations be doing about it to really do it right and make sure that they're doing it right? And what is a status determination issuance and just really everything about that. So Gareth Walls, who's a partner in A&L Good Bodies in Northern Ireland, is going to cover that. And of course, I didn't introduce Julia or Gareth properly, so I haven't done one of these in a while, but Julia is founder at iWork, and Julia has been a leading campaigner for independent workers' rights in the UK. She's a noted public speaker and expert in this field. Prior to that, Julia was the CEO of the FCSA body in the United Kingdom. So Sorry I didn't formally introduce you guys, but a very warm welcome to you both. It's just, I suppose I've known you so long, guys, now it just feels natural. So anyway, that aside, Gareth, would you care to just delve into the detail on IR35, just to educate our audience and really restate the problem? Thank you.
Super, thank you, and thank you for the introduction, folks. So it's really good to be with you all again today. So IR35, it's not a new piece at all. It's just effectively an expansion of existing tax rules. And what it's seeking to do ultimately is to prevent the avoidance of employment-related tax not being paid to the correct source to the exchequer. Ultimately, its focus is on the use of personal service companies, PSCs. We'll probably use that phrase or phraseology a number of times, or the single person corporate vehicle, which has been established and is something that the government ultimately wanted to close down in relation to misuse of the existing tax regime. So it is something that's been with us for some time, and it is gradually being narrowed and focused on. It's been in the public sector for some time. They've been through a huge exchange on that, and it's been fraught. The idea being that once the public sector scenario was ironed out, then it would be rolled out into the private sector. And that, even with pandemic and one thing and another, was delayed for a year, and that's what Connor references. It is in play now, and we do have this soft landing, which in theory is a fairly concessionary approach by HMRC in terms of enforcement. Now, Julia and I and Connor have talked about this over a year ago, and we knew about the soft landing, we knew about the legislative approach, but what we always anticipated is a pragmatic approach to this. And one of those things is making sure that entities out there are taking the steps that we think a pragmatic and a prudent employer and an entity should do to try and minimize the risk once HMRC and once the CEST tool ironed out all their issues. Now, as we're going to discuss, those issues have not been ironed out at all. If anything, they're being amplified. Connor's figures are absolutely right. 21% got an indeterminate status. That is no good to man or beast. What's worse behind that phraseology, actually, in that figure, is that so many more users of that CEST tool will have been given a result that they are dissatisfied with, or they certainly don't feel that they can work with or rely upon. And that's true whenever you unpick the CEST tool and its creators. Ultimately, it's an HMRC piece, but it's seeking to deal with a question which has been a question that has been at the forefront of lawyers' minds in the UK for 20, 30 years, which is, what is an employee as a matter of law, which is a tricky piece and constantly flexes and changes, and we see that with zero-hour contract workers, et cetera, but the other problem with that is the CEST tool is really looking at what is an employee from a tax perspective, and those two interests are they're maybe not fair to say they're competing, but they're certainly not complementary, and that is one of the real reasons as to why the CEST tool is an unacceptable tool for employers and for entities to use, because it seeks to try and meld tax issues and with pure legal issues in relation to status. It cannot do that easily. It does not do that well, and it creates an awful lot of issues for us. And you think about any other kind of UK legislation enforced by or with the government where there is an enforcement piece and they actually acknowledge that there's to be a soft landing. The CEST tool is acknowledged by HMRC to be an indeterminate piece which needs work, and they're still trying to fix that. So you can see why we have the issues that we do. And unfortunately, you can see why there is ambiguity in the workplace. And some organizations are seeking to work through the 21% or the million users, the million applicants. Some organizations are actually burying their head, quite understandably, because it's so complex and they're waiting to see what the UK government will do and finally sort it out and then think about it. But when you consider that in practical purposes for the individual, some suppliers are simply no longer going to be used by an organization, because when you audit your payroll and you think about status determination statements, and we'll look at that in due course in the course of this quo. Some organizations are taking the path of least resistance to say, actually, we don't want any ambiguity. We don't even want to have to go through this process. We are just going to stop using certain entities. And that's not good for the business, and it's certainly not good for the third-party supplier, if you like. So it's an unhappy place to be. And, you know, most lawyers sit in the fence about certain things. I just think it's a bit of a mess. It's not good for the business community, and it's not good for the individuals, and it's certainly not a good reflection for HMRC. And I've got some interesting figures to share with you all later in relation to the litigation hit rate for HMRC, even when they get through to enforcement. But we'll maybe talk about that later as we get through the session.
Wonderful, thanks, Gareth. So Julia, what's your take on this? What's going on? What's the problem?
Oh gosh, well, I could talk for a very long time about the problems here, but yeah, I mean, what Gareth says is absolutely right. It is a mess, and the decisions that some companies are making to stop engaging people through their limited companies, and by the way, working through your limited company is perfectly legitimate, and I am quite frustrated that there has now been this kind of connotation that that somehow it's dodgy. It is absolutely not dodgy, and it's perfectly reasonable way to work through a limited company if you're self-employed. So anyway, that aside, decisions that companies are making to no longer engage people through their limited companies are having a huge knock-on impact on them. And I was talking to someone recently, and they lost probably about £80,000 worth of income, just as one person, just by the some of the large clients that he had been working for deciding, no, we don't want to engage you through your limited company. And the ridiculous thing is that they won't engage him as a sole trader either. So he's kind of got nowhere to go, and he's having to change his whole business approach and that sort of thing. And just the final point on this particular example is the only reason he was working through a limited company in the first place was because that's what his clients wanted. So you know, he set himself up to work in that way. It's now been taken away from him. He now can't work as a sole trader either because they won't engage him that way. So he's lost all this money. And this was obviously at the height of COVID as well last year. And so this is just one person. When you think about the number of people who've been impacted by this legislation, then you are talking serious numbers. And yeah, the whole thing is a bit of a mess. I'm not sure I've answered the question. I've just started rambling on, I'm afraid, Connor.
No, that's good, Julia. I think many of, it sounds like you and Gareth, and I'm sure our listeners will share those same frustrations. So what I was hoping to do, I've got 2 points to make, if I may. One, so I like to simplify things in all areas of life, and one might make the argument that IR35 in private sector cannot be simplified, but maybe I could simplify it, at least in my terms. And Gareth, listen, of course you're the legal expert on the call, right? And it's not advice or anything like that, right? It's non-binding. It's just your opinion based on your experience and all that, right? So we'll caveat it with that, right? But let's say you're a private sector organization and you meet all the criteria that you have to go down the IR35 decision route or certification route, and you actually want to engage personal service companies, right? You don't want to make a blanket ban. You know that you need that flexible talent to come in to do a specific job, task, whatever, right? So it's pretty simple as I see it, right? So you classify the worker, you put them through a CEST type tool. Well, firstly, you identify who the workers are, right, that are in scope for this exercise. You put them through some sort of classification tool. We're going to come on to that in a second, that the CEST tool might not be the most suitable one to use, but there are plenty others out there, right? So that will spit out an inside or outside determination, and hopefully not an indeterminate designation, right? So you issue the worker, the PSC entity, a status determination statement, which outlines whether they're inside or outside IR35. Depending on if they're inside IR35, then essentially they will be taxed at source by the payment intermediary. And if they're outside IR35, they continue as usual. They receive gross payments and all that. In its simplest terms, is that the obligations on elements of the elements of the end user, the worker, and the payroll intermediary?
Yeah, it is. It is. So if you're taking a practical approach to this, and we could talk all day long about the frustrations and the lack of clarity in the legislation, but that doesn't really get us anywhere. That's just really for grumbling purposes. So I think the pragmatic approach to this is acknowledge that there is a potential issue and ultimately a potential liability for the business if we get this wrong. So what do we need to do for the purpose of HMRC enforcement and compliance? And it starts with an audit of your workforce, and I use that term in the non-legal sense. It is everyone in your P&L who is supplying a service. Some will be belt and braces employees, others will be absolutely third-party contractors, but it's working in the gray areas, if you like, and conducting your best analysis of that. It means, and I'm not I'm not making work for myself here, it means actually a three-way conversation, I think, with a lawyer who knows what they're talking about in relation to this field, your accountant, stroke auditor, and operations within your business. So you have a proper understanding of X, what they do, when they do it, how they're paid, how frequent, et cetera, and within that, the employment lawyer will probably talk about control tests and the various things which deal with status. So you augment that then with a run through the CEST tool. And one of your questions actually, which I'm seeing from Michael, is really interesting and helpful. How does the 21%, is that because of poor questions or grey scoring? You know, so I think we have to do a prep before we start the CEST analysis. And that is not just one pillar in that pyramid, if you like, it is input from all three. When you do that, you have an answer. Bearing in mind, this is where the government is passing responsibility onto the employer. So what I would then suggest practically, what we do is we communicate our rationale for our status determination, and we communicate that to the entity that we're talking about and who we have assessed. And we give them a little bit of time, and this is within the rules and the expectations, to come back and say, well, actually, I don't agree. And these are the following reasons why I don't agree. And here's some supporting evidence from my accountant or my legal team, for example. I have no problem with that piece coming back in because it allows you to make a more informed decision. But once you have gone through that process, and if there's no comeback whatsoever from the individual, then you apply it and you start paying and making the tax deductions as you consider fit, if they are in fact within IR35. And at least we have a paper trail and we have a considered judgment rationale for what we've done, and we have applied that, and we've given the individual, the external individual, the opportunity to challenge and put in a contrary pitch. That, to my mind, is what everybody should be doing, so that when and if an investigator does land, we have the illustration to show and we have an immediate response to that. And when you get into an understanding of how the HMRC investigators themselves are approaching this, and this is why I said I'd talk to some of the things we're seeing and hearing, I think that first considered approach response is going to be essential for a business that is seeking to avoid criticism or enforcement in due course. So that's the pragmatic approach to it, Connor.
Yeah, and I think there's a lot to be said for that pragmatic and simplification approach. I mean, really what you want to show is that you've made your best reasonable efforts to audit, categorize, communicate those workers, and that you've made the appropriate designation based on your understanding of the rules and regulations, right? So that must offer a degree of protection in the event of an audit, right? That you can show that reasonable due care, if you like.
Yeah, absolutely. And I think this I'll lead into where the soft landing is heading in that. It absolutely will give some comfort and some immediate protection from prosecution. It will not be an absolute protection. But if you consider what HMRC are establishing themselves when they go out on this, they are seeing an awful lot of organizations, notwithstanding the passage of time, are still not engaging with this at all. So that creates a problem for them. They cannot investigate and enforce against everyone. So I think there's an unspoken recognition that the legislation is not as clear as it could and should be, and because there's no binary and easy piece to this, particularly in relation to status of worker and the capacity for a lot of litigation and contested litigation on it. The soft landing officially is over, but I still think they are taking the time in relation to rolling out the enforcement piece. But they are confirming that they have initially started to target the oil and gas sector, rich pickings initially, and then they're going to cascade it down. So I still think that much of the private sector has time to get this right. But I still think that the response to that should be, don't put it off anymore. Conduct your audit, do what you can in relation to the information between your external lawyer, your auditor stroke accountant, and your operations team. Phraseology will be different in every organization, but I do think that analysis needs to be done and audit the supply chain, the workforce, get that communication out there, because that gives you a first line of defense to prosecution. It will not be a blanket defense, but it needs to start, and it really should start now. Doing nothing is not an answer. Not for you as a business, and it's certainly not the case for the individuals who you want to continue to work with and who bring a skill set that we absolutely need. And Julia's example is one of the big issues with this is as we continue to have a lack of clarity, what we're seeing is businesses just choosing not to use PSC contractors in the supply chain to minimize tax risk, and that is not a good place to be. And the UK government should have been better in this. HMRC should be better in this, and we are heading to a place of greater enforcement, but it's starting with oil and gas, and it's going to cascade. So doing nothing is no longer an option. This time last year in August, it might have been an easier place to stay and to land on that in the short term while we see how things pan out. No longer a position statement for us, I think.
Yeah, and Julia, would you have anything to add to that, or what's your experience in terms of what Gareth has said? Thanks, Gareth.
Yeah, I mean, I would certainly echo what Gareth has been saying. I think it's particularly important to keep records, and I know Gareth said that in terms of and dated records as well. So if you are using the CEST tool, then you need to know when you've used it, because we know that they are making changes to that. So yeah, just keep records of absolutely everything, so you can explain if you need to why you've reached a particular status determination and the reasons for it, and all of those processes that you've gone through. If you're not keeping records, you don't have a defendable position. It's as simple as that. So you know, you can't afford to do this by half measures at all.
Thanks, Julia. I mean, it strikes me, guys, just in relation to the soft landing, I can't think of any new legislation that's ever been introduced where essentially there's an amnesty of sorts right off the bat. Of course, you think back to gun control in mainland UK or United Kingdom, there was laws about what sort of weapons you could hold, and then an amnesty was brought in, essentially allowing people to hand those weapons in, right? But I can't think of a new law that's ever come in where essentially there's been an amnesty and the government has said, or the government body or agency has said, hey, listen, you're good for a year and we're going to start looking at that now. Is that fair comment, Gareth, in your experience?
It is, Connor, but it's also the case you're beginning to see the UK government beginning to do that as it gradually shifts responsibility from the state collectively into the private sector to manage and monitor and maintain certain standards. They are giving people longer, time to get up to speed. Modern slavery legislation is another illustrator of that. The legislation has been with us since 2015, but the enforcement wing of that hasn't really kicked in. They're using other pieces of legislation to enforce, but what they're doing with that behind the scenes is constantly widening the scope of that legislation to make the private sector employer responsible for far more than just national minimum wage. For example, it's also in relation to eradication of modern slavery, it's working time regs, enforcement, etc., etc. So that is a little bit of a theme, but while we're on it, just a couple of quotes. I think this is HMRC talking here, and this illustrates just how nervous they are in relation to their approach to litigation. So HMRC will seek to handle disputes non-confrontationally and by working collaboratively with the customer. In the majority of cases, this is likely to be the most effective and efficient approach. Okay, so that is not a binary enforcement piece. We get it. HMRC will not usually persist with a tax dispute unless it potentially secures the best practicable return for the exchequer. And HMRC, this is the bit I like, and HMRC has a case which it believes would be successful in litigation. So they're setting themselves a relatively high bar there in terms of going to litigation. You, in theory, they're doing their due diligence on this, and yet specific information enforcement rates, HMRC IR35 wise are only winning outright 36% of the cases they are bringing. So even with their slow burn entry into litigation, even with the tests and the standards they're setting themselves, they're only winning about 36% of the cases they bring. Now, the flip side to that is some of the cases they do bring are real headline grabbers, because the Department for Work and Pensions got hit with an 88 million tax bill in July 2021. So yes, there are some big wins, but that was off another government department. The litigation they're bringing against the private sector entities has a 36% hit rate or success rate. So you can see why, yes, soft landing is over, but they're still reticent to litigate because they don't have a successful hit rate.
Yeah, it's interesting, Gareth, that three-stage criteria that HMRC have outlined there. They're basically only looking for 100% winnable cases, right? So you take those odds every time if you're on the other side, correct?
Absolutely, absolutely. Now that has to change. They can't sustain that. Otherwise, effectively they're accepting that everything they've done to IR35 has been a failure. So I can. This is why you can have a little bit of a smile at it.
Yes.
But I go back to the point I made previously. Doing nothing is no longer an option. The direction of travel is one way.
Yeah.
It's been a slow start and an unimpressive start enforcement strategy wise, but it's not going to change. And I think we all have to take action, not just as a defensive play against HMRC, but as a progressive piece in relation to getting and using resource out there properly for our businesses.
Yeah, I think that's fair comment. And like Gareth, Julia, thankfully, and I'm knocking on wood here, our organisation and me personally have never been investigated by HMRC. What does it look like when they suddenly knock on your door, right, in relation to IR35? Would you be able to paint a picture of what the process looks like when they come to investigate you as an organisation? How scary is it?
Julia, do you want to?
I mean, I can have a stab initially, and then you can give the facts from your side, Gareth. But yeah, I mean, it's terrifying for workers because the amount of money at stake is enormous, and you know and again, like I said before about keeping evidence from your side, if you're the company engaging the worker, then obviously the individuals themselves need to keep their evidence as well, and so they've got a defendable position. But the sums of money are huge, and the ones that hit the headlines, you know, like the TV presenters, they tend to be kind of in the millions of tax liability potentially. So yeah, and I suppose the first thing you would do is don't panic, and that's easy to say, and you know, get some good kind of advice from kind of tax lawyers and what have you. There are insurance policies out there which offer varying degrees of protection, so you need to be careful about whatever insurance policy you might be choosing. Some will offer tax loss insurance cover, and others it just depends on exactly what you're buying. But I can see there's a question in the chat actually about contractors buying insurance cover that will kind of potentially protect the whole supply chain. Now, my understanding from the contractor's perspective is actually in this new world of the legislation, the people that are liable is the company, not the worker. So therefore, theoretically, contractors shouldn't need that insurance themselves, and they certainly shouldn't be indemnifying the rest of the supply chain. But that's my perspective in terms of what I do is support the worker view. So yeah, that I would take that view, wouldn't I? But I don't know if anyone has a different thought.
Yeah, Julia, I want to come. I think that question is an excellent one. Reading that question filled me with absolute dread and horror, right? Because, and no offense, Keith, it's a great bloody question, by the way, but how can you as a PSC contractor ensure against reputational, criminal, civil, and financial sanctions, right? How can you ensure against that across a supply chain where the tax liability rests back with the end user in terms of that entity or organization's determination as to your inside or outside status, and also any payment intermediary that's in between? That strikes me as insane, and I have seen those products out there, Julia.
Yeah.
But Gareth, what's your take on this? Maybe my position is a bit extreme, but anytime I see something like that, it strikes me a bit like, when I was living in Dublin in 2007, every single taxi I got into, the taxi driver was telling me to buy property in Bulgaria, right? And that didn't go very well for the Bulgarian property sector or for those holding Bulgarian properties. So it,
Yeah.
is my comparison, whilst funny to me, is there any merit in what I'm saying?
Well, yeah, look, yeah, and I go back a point when you said, what does it feel like for anyone being investigated? Julia used the same word I was going to use, which is terrifying. Because it attacks absolutely everything at the core of your work and your ability to earn a living for yourself and your family, etc. So when you're being investigated by the government in relation to your tax status, it is a huge shock to the system. And I have seen a lot of very sophisticated businesses and individuals who are absolutely brilliant in their chosen field, but they are completely unnerved whenever this kind of thing occurs. And it doesn't really get much easier, because even if you go to external advisors who are really good at what they do, the length of time it takes to work through this, the delay, the uncertainty that's hanging over you, and the implied criticism and the implied guilt. So you're almost guilty until you prove yourself innocent in this scenario. And it's an awful place to be. And some of the inspectors who come and do the first level interaction are very intransigent. They're not pragmatic. They are not soft and warm exchange type people. It is hard details, facts. And by the way, and if you don't comply, and if you don't provide us what we want, well, we're going to go and get an order and come back and lift and take whatever we want. Computer systems, records, everything, depending on how aggressive they seek to be. And that is not just a criticism then and an impact on your historic financial trading, and is there a tax liability and a penalty coming? But apart from that, it's like, well, how on earth do I have business going forward? How do I accept a job going forward, etc. So it's a really, really tricky and unpleasant place to be. And there's nothing funny about it at all for anyone who has ever been hit with that kind of an investigation and a scenario. The second piece you're talking to, moving forward, look, I would agree with everything you're saying as well. It's a very difficult place to be for anybody who has a PSC, and when you're being expected, in a sense, to take out an insurance policy to guarantee and to guard against the act or the omissions of others, that just doesn't feel right for the individual. And I'm also wary of whether the other reaction, quite apart from the insurance policy piece, which we touched on, is we're also seeing, or we're being asked to draft into commercial contracts for entities who have bargaining power to say, if we use X as a supplier, and if there is a liability in relation to breach of IR35 after we've done our status determination assessments, well, actually, the full liability for that will land with the PSC. So whether or not that ultimately would be unlawful if it ever got tested, the reality is the unlawfulness or otherwise of that is something to be adjudged by a court maybe 2-3 years down the line, whereas the need for the PSC is to get into that commercial contract and do the business and earn a living now. So people are being asked to expect or to accept in commercial contracts liabilities in relation to this, which they would not normally be exposed to. And that is another very difficult and unfair outflow of this, which I don't think the government considered at all, but that's how business is responding to it. So real issues there, both on the insurance side, the commercial contracting side in relation to warranties, indemnities, which really shouldn't be there as a consequence of this development of IR35 into the private sector. So lots and lots of really big issues just to work through.
Yeah, I think it's that old cliche of the law of unintended consequences, and I think they're manifold and manifest in relation to this particular piece of legislation as it's drafted and also sadly implemented. There's a really interesting question, both Julia and Gareth, that we've had on a number of our webinars over the last 2 years, and again, thanks to you guys for always participating and leading the line. But the question in short is, what happens when a company, and I assume the company Jacqueline refers to, the end user company, is engaging remote workers that are it doesn't say this, but I'm assuming that the remote workers are PSC workers in the UK. So my understanding from the legislation is that the end user needs to have a UK association or presence, but a UK association to essentially put those workers through an IR35 determination process. So if the company doesn't have a UK association, must they put a worker through an IR35 process, or does the original IR35 legislation as it was drafted put the onus back on the PSC worker to be compliant with IR35? So Gareth, Julia, what's your take on that, and am I factually incorrect in my understanding?
No, I don't think you are factually incorrect, but it's a great question, but it's very difficult to answer because you have to do investigation into the entity. There has to be some kind of a UK presence. If that is just a brass plate, by that I mean, is it just a registered office somewhere and there's no physical presence, there's no personnel, and actually it's just a conduit for a fully external international organization with no other presence and no other presence in the UK. Arguably, whilst the legislation will impact on whoever is involved in the supply chain in the UK, who do you prosecute? And that's something that HMRC would have to factor in. What is the point of kicking off litigation against something which is a shell and has no direct connectivity, and they can't necessarily enforce UK legislation external to the UK? So the answer to that in terms of prosecutions really depends on a proper analysis of who the end or who the contracting entity is, and whether it's just a brass plate office building somewhere in the UK. So it's tricky to answer. So I suppose what I'd really want to do there is to get under the skin and do a little bit of due diligence on the various entities and where they are located before you answer that properly. The PSC, if the PSC is based here, then they're fair game from the HMRC's perspective. I don't know if the question is getting into, well, what happens if the PSC is registered, for example, in Dublin, or whether it's registered in South Africa, or whether it's registered in the Cayman Islands. Does that obviate liability? It won't. It won't. That can be pierced by HMRC, because if the individual supplying the services is domiciled resident and the business is conducted here, it doesn't really matter where it's registered. It can be targeted.
Understood. So just for clarity, Gareth, Jacqueline's organisation does not have an entity in the UK, but the workers, the PSC workers, are in the UK. So my understanding is that the liability, well, it's going to be difficult for HMRC to target a US company and ensure that they do IR35 tests. So my understanding is that the liability rests with the PSC worker, that she or he or the directors or shareholders of that company are essentially IR35 compliant with the existing legislative framework, correct?
Yeah.
Now, there is, Jacqueline, sorry, I don't want to go too much into a weird tax tangent, but there's potentially an argument to be made that there might be some sort of establishment for your entity. So let's say you have 1,000 PSC workers in the UK and you've engaged them for 20 odd years, right? So there might be some issues around permanent establishment and things like that, but we probably don't have time to get into that.
We're actually quite small. So we're just looking. We don't want our contractors to be liable either. We don't want bad things to happen to them either. We're just wondering, will we even just avoid hiring in the UK? We don't want that to happen either. So that's just our concern at the moment.
Yeah, well, I suppose we don't want to give you specific advice, Jacqueline, but Gareth, Julia, would you just care to comment on a no-names basis? I mean, is there any reason not to engage these workers? On the face of it, there doesn't seem to be, from my perspective.
My own understanding matches yours, Connor, in terms of the original IR35 legislation would apply to the individual rather than to the business engaging that individual. So yeah, please don't stop hiring UK people if you need them for your business. I mean, this is the worst possible news to hear. And I'm not for 1 minute telling you what to do. Of course, I'm not. But I do know that this has been the reality of what's been going on, and that some companies are reluctant to do business in the UK because of it.
Yeah, and Jacqueline, the previous IR35 legislation has been around for nearly 20 odd years, so those PSC workers will be bound by that anyway, right? They have to fulfill their obligations in relation to that, so that will never go away anyway, particularly because there's no UK connection, because you don't have a UK entity. So hopefully those workers are aware of that and following the IR35 rules as they were drafted 20 odd years ago. But I don't think it's a cause for concern for you guys at the moment.
Okay, thanks very much, guys.
This is good. Solving problems in real time. This is what it's all about, guys. But Jacqueline, you're not the first guest on these series of shows to ask that particular question. So, guys, I want to come on to the CEST tool, and of course, but Gareth, you mentioned it previously, and we talked about the inadequacies of it because it's essentially throwing out 21% indeterminate status. So, Julia, would you care to give your views on the CEST tool? And what the hell are the problems with it?
Sorry, slight delay unmuting for some reason. So yeah, in terms of the tool, the major thing that it still doesn't have is this thing called mutuality of obligations, which in very, very simple terms, if an employee is employed, then they are obliged to do work for their employer, and the employer is obliged to provide ongoing work for the employee. That, in a nutshell, is what mutuality of obligations is. Now, the CEST tool does not include that, even though it's often and used as an indicator of employment status. Now, the reason why it doesn't include that is probably because it's quite difficult to put that into kind of into a technical kind of program. It's kind of a nebulous concept. So that's probably the real reason why it's not there. However, there have been loads of cases over the years which mutuality of obligations is the tipping point in terms of whether someone is genuinely working for themselves rather than being an employee. And it's scandalous that it is not included in the tool, because it's been known for years that this is an important indicator. So for me, the tool misses that hugely important part of assessing status, and I don't really think that anyone should be using it. The other side to the equation that I would like to mention in relation to the CEST tool is that apparently HMRC will stand by you if you use it. Well, we know that is not the case. We know plenty of public sector companies have used the tool, and quite a few high-profile cases, the one that Gareth mentioned earlier, actually, whereby they've been fined by HMRC for not implementing the new rules properly, yet they've used the tool, but they've used the tool incorrectly. So HMRC have not stood by those companies and have fined them anyway. So I would suggest to anyone listening that actually you would be better off to probably get something more bespoke that does cover all of these things. And there are tools out there. You do not have to use HMRC's one.
Thanks, Julia. Gareth, would you care to comment on the same issue, please?
Yes. Sorry, I'm muting again. No, I'd echo everything Julia said. As I said at the start, the CEST tool is a HMRC creation which seeks to try and answer age-old concerns about what is an employee stroke worker for tax purposes versus what is an employee stroke worker, the legal issue. The mutuality of obligation is one of the key aspects. It's quite amorphous. It's a concept. It doesn't fit in a machine. It will not pump out the right information. The secondary set of employment law tools, you know, the control test, the various factors that drop in, it seeks to try and do. Again, it's not going to be able to pop out the correct answer. And in and of itself, it's not going to work, which is why everybody acknowledges it has its faults. And as we just talked through that, I noticed Michael's question. I think it's a very interesting one. Ultimately, he's heard that some insurance underwriters are covering SaaS tech solutions that deliver classification determinations. This is a bit enabling the tech platform to offer indemnifications to end clients. Not aware of this coverage in intermediary service providers, though. Have you seen any of this regarding compliance tech? Is it going to work? So I think knowing what we know about CEST tool and that it is an imprecise and unreliable piece, but it is part of the picture. What do you do to augment that? Now, I talked about some things we can do earlier. I'll not rehearse that. But I just wonder, you know, the indemnification piece is the thing that always excites me. But I'm not so sure that that's just a form of insurance. I'm not so sure that an indemnity is going to work, because to get that indemnity, you're going to still have to go through whatever that platform provides. You're going to have to provide information that goes back, actually, Michael, to your earlier point. How do you answer the questions clearly in a way which is going to be stood over? And if the questions aren't formed properly by someone who has an understanding of the legal, the tax, mutuality of obligation, control test, I just don't think it's going to work. So even if someone is trying to pump out a product to meet this short-term need, I think it's going to be a short-term need. And I don't know that I would be buying it. To my mind, paying money to a third party to help me through this and getting an indemnity is a bit like buying your Bulgarian property, Connor.
Yeah, I agree. I'm suspicious of anything that seeks to insure away any legal, criminal, or civil penalty or sanction. And that's what I really want to get on to now, folks, particularly for those people that aren't aware of how bloody reputationally and financially arduous it can be for an organization to get this wrong. So, Gareth, for the benefit of our audience, would you kindly walk us through the fines and the risk regime of getting this wrong? As I understand it, there's almost 3 grades to it, but I haven't looked at this for a while.
No, well, actually, I was thinking, and I don't want to put you on the spot, Julie, but I think if you even answered that from your perspective, working with individuals who have seen it at face value, it might be more interesting than a bog standard analysis of the law.
Yeah. Fair. I think our understanding of the risk regime is there's those that have just got it wrong. They haven't followed the process. There was no willful conspiracy, if you like, or willful desire to do that. They just haven't done it in a correct way. But there was no intention for them to game the system. There's no intention for them to hide things or do things incorrectly. And I think my understanding on the fine and the risk regime is that there's less fines applicable where it's non-willful. But if it's willful disregard for the legislation and it's planned, then there's quite a significant fine regime, as I understand it, Gareth. I just can't remember what the quantum is.
No, I mean, you're right. And across the jurisdictions, the fine print, the penalty regimes are ever so slightly different. But we're looking at penalty fines. We're looking at having to pay HMRC's investigators costs. We're looking at the issue in terms of remedying the bill, which would have gone back to the exchequer, as I made the point earlier, plus interest on that. So the fee regime, fine regime is very, very significant if ultimately there is a prosecution. And bearing in mind, we get notification of a prosecution. It may take a year and a half to get to court, but all that time, the interest keeps accruing. And on that, one of the other interesting points HMRC are acknowledging is that where they will not persist with a tax dispute unless it potentially secures the best practical return. And what they're actually suggesting and confirming is that once they kick off an issue, they are open to discussion and dialogue and negotiation and settlement before they actually get to court. So they are seeking to try and be pragmatic, but I'm not seeing that so much. On the contrary, I'm involved in a piece at the minute where the HMRC have no interest whatsoever in commercial resolution or even acknowledging some of the mitigation pieces that you reference as a first stage entry. And instead, they're suggesting, what I see effectively no true evidence, that there was an intention to avoid a form of malice, and consequently they are throwing the book at it. And that is a private sector prosecution in Northern Ireland at the moment, that it's going to cost hundreds of thousands of pounds if they're successful. So they're bringing an awful lot of pressure to bear, I think quite unfairly, but I think they're looking for a trophy headline, is my view, and they're avoiding what they say they will. They're avoiding their own guidelines in relation to approach to a matter. Yeah. But that's as much as I really want to say in that.
Fair enough, Gareth. And I mean, Julia, to my mind, it's instructive of what the HMRC's approach is likely going to be. If you look at what happened in the UK public sector last year, I think the total quantum of fines issued to 3 separate UK government departments that had got this wrong was around 800 million UK pounds in that region. I might have got that wrong, but it sounds about right. But anyway, it was significant multi-100 million type fine with back penalties and whatnot. And my understanding, Julia, is that it's quite likely that the bigger you are as an entity or an organization or end user, the likelier it is for HMRC to go after you first, now that this soft landing period has ended. But what's your take on the penalties, the reputational risk, what they're going to do next, Julia?
Yeah, I mean, it's huge. The figures are massive in terms of the cases that we know about, and of course, some cases will have been settled before kind of we even know about them. So there's that side to it as well. And I'm pretty sure in one of those public sector cases that there was an element of the fine that HMRC was saying was due to a lack of care on the part of the client business. And that sort of stuck in my mind because I was fairly sure that this client had used the CEST tool. So I was kind of rubbing my hands together in the sense of, well, they've used the CEST tool and yet they're being done for lack of care. And one of my points is that CEST is not really fit for purpose. Now, unfortunately for me, I can't remember which client it was or the details, so I can't give you any more information about it, unfortunately. But that is, I'm sure, what happened. So in terms of kind of going forwards and what to expect, I think you're quite right. I think the large companies are going to be a target because if you're a large company, the likelihood is that you're engaging contractors more frequently than a smaller company. Therefore, it makes sense to go after a larger company for that reason. So then you can kind of mop up a lot of potential non-compliance in one hit. So that does make sense. Other factors, HMRC have access to an awful lot of data and information. So they might look at particular risk factors in people's tax returns and things like that will inform what they do. Now, that's probably more old school. That's a bit more when they're targeting individual workers themselves before these legislation changes came in. I think now we've got the new legislation. I think you're quite right. I think they will have some sectors that they believe as riskier than others as well. So it will be a combination of company size and whichever sectors you're working in. I think anyway.
Thanks, Julian. I suppose final question to you both, guys. How concerned are you both about the future flexibility of the UK labour market as it pertains to IR35?
well, very. I mean, things are settling down now out there. That said, there's still quite a few companies that I would expect to know this stuff who apparently don't appear to. So yesterday I heard of a large supermarket, for example, who didn't know who was responsible for doing status determination, and I just thought, well, that's a little bit silly, considering you should have been doing it for at least a year now. Anyway, that aside, yeah, I am worried, and just the case in point from this afternoon's call, actually, the lady who was on before sort of saying, well, I don't know whether to engage workers based in the UK. Well, that's so worrying, because actually the economy needs people to want to do business with people based in the UK, and it doesn't surprise me, that concern, and I think it's potentially a valid concern, and I just think that the impact is way bigger than HMRC ever would have thought, and also the impact on people's individual finances and running their businesses and entrepreneurship, etc., etc. It's still a concern, and I just hope that things will move on, and that we will find ourselves in a more positive place, maybe in 12 months' time, something like that.
Thanks, Julia. Gareth, over to you, sir.
Yeah, I completely agreed. And as I said it there, it's an IR35 as a set of tax rules which have been amended over time. It's not a new thing, but it's a piece of legislation which was created pre-pandemic, or the latest iteration pre-pandemic, and then a little bit of enforcement lag. But we have a US entity here that is seeking to use UK-based PSCs and is querying, because of the lack of clarity in the rules here, do I really want to? Well, that's a worrying piece for us in terms of the future of work, but also it's just illustrative of how the UK government legislation, IR35, has not been geared to consider the impact of pandemic from home and a fluid and global workforce. So again, that is another area whereby, as they consider what they need to do with this, they need to really listen to organizations who are prepared to lobby and consult and inform, and make them realize that actually the future of work is not anywhere close to 80+% of your working population being in a factory unit 9 to 5, Monday to Friday. It's just not. And consequently, having really quite old school tax and revenue principles and tweaking them, but not fundamentally changing them for the new world economy, is no longer acceptable, because it's going to have a bigger impact on the UK economy than anything else. And fundamentally, if you consider what this is all about, it's getting money into the exchequer's purse. Actually, step back, take a proper belt and braces review and approach to this, and come back with something a lot more meaningful and fluid, and that will chime with the future of work and what our business community is requiring. But the other element to this, and I'll finish in this, is employers have not helped themselves sometimes by seeking to be really inappropriate with employee and employee rights. The inappropriate use of things like 0-hour contract workers, even hybrid working, work from home now, and post-pandemic working. We're seeing it all the time. Employers are not, it's like Snapchat. It's brilliant whenever it's first comes on the scene, but it can be used and abused. An awful lot of employers, unfortunately, are using and abusing their status and taking advantage of employees, workers, PSCs. That needs to be fixed as well. That's part of the answer.
Yeah, I concur with both your analysis. I'm really concerned for the flexibility of the UK labour force. I agree with you. I don't think it reflects the new world of working, or even the previous way of working. And my concern is, where does HMRC go next, right? What category of workers do they go after next? If they go big bang with IR35 private sector, now the soft landing's over, are they going to focus on sole traders next? Are they going to go after and essentially look to tax sole traders at source, right? And that's a huge hidden workforce segment in the UK economy. It's essentially hiding in plain sight. Little is known about it. Little is known about the risks about it for the end users in particular. So I think we need to watch the space and see where it lands. But my suspicion is that HMRC are coming for that category next. but that's what do I know. Guys, I just want to say thanks so much. We're coming up to the close of today's webinar. Julia, thank you very much indeed for your ever interesting analysis and input. Gareth, thanks ever so much for your expertise and your analysis too. It's been a pleasure speaking with you both, and thanks also to all of our audience today and for all your questions, from Jacqueline to Keith to Michael and everyone else. So have a great day ahead, folks. Thank you very much.
Thank you.
Thanks.